Okay, we can probably kick it off here. Be respectful of everyone's time. I really appreciate you guys coming out. Everybody joining us here. It's good to see your names at least again on my list here. I look forward to catching up with everybody here coming up into the new year. I know January is a natural time for everybody to take a look at their financial plans, and a lot of questions that I get really do surround like a lot of what you do, and that is, we plan and we build and we work and we have these whole financial lives that we build up, and they got to go somewhere someday. And if anybody has ever met my daughter, they know that your kids are both difficult, but you love them more than anything. And so having in place the proper legal tools to effectively handle your estate it's a big deal. So a lot of times I field questions, and for everybody listening, you may not know this about kind of every industry has its own kind of inside baseball. Finding an attorney who is personable and experienced, and you just know that you're getting treated fairly, and it's actually a very rare thing. You would think you could look up in the Martindale Guide or wherever it is and pick someone out of the phone book, but the next thing you know, the bills come in, but the emails don't get responded to and all that kind of stuff. So when I can find somebody like Kanoa that I can go out and sit down and have a cup of coffee with and just talk things through with, and has Megan on his team, and if you never have been looking around for help of the sort that Kanoa provides, it's very, very difficult to find somebody. And I think, or I would hope, a lot of my clients would say the same thing about me. So I'm super excited to introduce Kanoa Ostrom. He started his own law firm. He's been doing it multiple decades, local to the Seattle area, and he has a good high level view of what I think a lot of my clients need, which is to take care of the legal things that are going to determine what happens to people in any number of scenarios. So Kanoa, I love the sound of my own voice, but I'll stop talking now and let you take it away.
Yeah, thanks, Chris. Really appreciate it. Glad to be here. So what we want to do is, what we like to do, Megan and I and our firm, is help people, but not be spending a ton of time on things that really just take a little bit of focus and a few critical decisions. So we're going to just give a quick little talk about what everybody needs, what you should be thinking about. People may hear this and think, oh, great, I've got this covered. Okay, that's peace of mind. Or, oh, wow, that's something I should look at again. Okay, so let's look at that again. So our goal is just kind of issue spot tonight, let you know what you need to have, kind of get rid of all the noise. There's a lot written about estate planning that doesn't apply to most people. And we want people to focus on just getting this set and checking it off their list and having peace of mind. So I'm going to have Megan start by just kind of explaining the 4 documents everybody needs to have. And then I'll talk about a couple more issues with trusts, and then we'll open it up to questions, if that sounds okay.
All right.
Yeah,
well, I'll get right into it then. Okay, so as Kanoa mentioned, there's really 4 estate planning documents that everyone should have, and I'll go over each of those. So the first is a medical power of attorney, and a medical power of attorney appoints the people who you want to make medical decisions on your behalf if you're unable to do so for yourself. So the medical power of attorney that we prepare for our clients make sure that we grant the medical power of attorney broad authority to exercise judgment and work with doctors to do what is in your best interest, given the circumstances at that time. So very important to have that covered. And then the second document is related to the medical power of attorney. It's a healthcare directive, otherwise known as a living will. And the healthcare directive is a document in which you indicate whether or not you want to receive life-prolonging measures at the end of your life. So really, it's just there to make an end-of-life decision easier on your loved ones and let them know your wishes. The healthcare directive doesn't tend to carry that much weight as it is. So really what's most important is that you have a medical power of attorney that appoints someone who you trust, and that you have conversations with your loved ones so that they really understand your end-of-life wishes. The third document that everyone should have is a financial power of attorney. And that's a document that appoints the people you want to pay your bills and manage your finances on your behalf if you were alive but incapacitated. So sometimes we also prepare a financial power of attorney that is effective immediately after it is signed. So if you're aging and you just don't really want to pay your bills and handle your finances on your own anymore, we can have you sign a financial power of attorney that's effective immediately, and then the person you trust can take over that for you, even if you're not incapacitated at that point. And having a financial power of attorney is important because it means that your family doesn't need to go to court to get a guardian appointed for you if and when you get to the point where you can't manage your finances on your own. And then the fourth document, the one that people have probably heard of the most, is a will. And a will says what you want to have happen to your estate when you die. So who your beneficiaries are and what you want to have happen to your property and how your assets should be distributed. A will also appoints a personal representative, otherwise known as an executor. Personal representative is the term that we use for an executor in Washington state, but in other states they use executor. So the personal representative is the person you want to administer your estate and carry out your wishes upon your death. And then in addition, very important for those who have minor children, a will also appoints a guardian for your minor children, so that if something happened to both parents before your kids turn 18, your will says who you would want to care for your kids in that event. So that's just kind of a very high level overview of the 4 core documents, estate planning documents that everyone should have. And then Kanoa will talk a little bit more in detail about those and talk about a 5th document.
Yep, muted. Yep.
The 5th document that really people is the most controversial, thing that people talk about, the most exciting but confusing part of estate planning is a revocable living trust. A lot of people hear that is a revocable living trust is amazing. It solves all your problems. It solves all your estate tax problems. It solves all your asset protection problems and saves you so much money. And in many states, that's true. So if you don't live in Washington, you probably need a revocable living trust, because the process when someone dies in most states is archaic and it takes a long time. And if the court's involved at all, it's a total nightmare. So if you live outside of Washington, or if you have property outside of Washington, but you live here, so let's say you live here and you have a house in California, then you do need a revocable living trust. And it's not that big of a deal to set one up. It's a little more work. It's a little more expense. But it really only avoids probate. Okay, so a living trust only avoids probate. It does not do any extra tax planning. It does not provide any extra asset protection planning. And what I mean by that is people think sometimes that if I set up a revocable living trust and I put my assets into the trust and then I get sued at work, all of that is protected. That's not the case. So a revocable living trust does not provide that protection. So don't rely on that. Don't get sold on that concept. It also doesn't have any extra estate tax protection. When you put money into a revocable living trust, you're still basically the owner when it comes to estate taxes. So it doesn't get it outside of your estate. It's not bad. It's just may not be what you think. Okay, so probate, big deal in many states. In Washington, it's really not that big of a deal. If you have a good will here, probate here is really not that big of a deal. Nobody goes to court. The fees are not dramatic. Things are done online or through the mail. You get appointed, you're able to deal with third parties. It tends to go pretty smooth as long as you have a good will. So a will in Washington works very much like a trust would work in California. California, you have to have the trust. Washington, you're probably okay with just a will as long as you don't have any out-of-state property. So we just like to point that out because people sometimes think I need to spend all this extra money in having a revocable living trust. Most people in Washington don't need one. They're oversold. Sometimes it's a marketing thing. They're not terrible, but you shouldn't be spending a lot of extra money on one if everything you have is in Washington. So that's the 5th potential document. In most states, people need them. Here, only if you have property out of state. And then, but most people do need trusts. Okay, most people within their estate plan do use trust, just not necessarily a revocable living trust. So the type of trust I'm talking about, and so this is not a separate document, but it's built into your will, or it's built into your revocable living trust, which as I said, is not a terrible thing, but maybe overkill. Built into those documents would be a testamentary trust. That's a trust that gets set up when you die. Why would you have a testamentary trust? Well, if you have kids, mom and dad die, you don't want the kids to just inherit the money. You want them to have a trust, but that trust doesn't have to be set up while you're still alive. It can just be set up under the terms of your will or your living trust. So that in the future, if you pass away while your kids are young, the money's managed by somebody that you trust. And it's only used for education and healthcare and help with a down payment on a house, things like that. Not letting anybody retire and live off of the trust fund when they're 18 years old. So that's why we use testamentary trust. It's the easiest concept to understand, is leaving a trust for minor children. But that's really a very small number of trusts that are set up, because thankfully people don't tend to pass away while their kids are young. So very few trusts end up being set up for children. That's a good thing. We don't see it very often. You know, we address that terrible circumstance by having the documents in place, but it really doesn't happen very much, thankfully. But trusts are still really good for other reasons. So why else would you use a trust? Well, if you're married and you die, oftentimes it's a good idea to leave your spouse a trust. Not because you don't trust your spouse, but because of estate taxes and asset protection and Medicaid planning. So what do I mean by that? So my own plan with my wife, I've been married for 25 years. We've got 2 kids. If I die, I'm leaving my wife a trust where she's the trustee. So she's still in control of the trust. She's the beneficiary. She has full access to the money in the trust. She can't give it to her new husband. I have made sure I have built that in. She can't give it to her cult if she joins a cult. You know, she can only use it for herself and eventually for the kids. So there are a few limitations, but generally she can use it as she sees fit. I'm not micromanaging her life, but that trust is protected from estate taxes. When she dies, it's not a part of her estate. If she remarries, it's protected. If she gets sued, it's protected. And then if she ends up in a nursing home someday, that trust can be protected from a Medicaid spend down. And that's a big deal, even if you've only got, you know, a fairly modest estate, but you want to leave something to your kids. Being able to protect it from late in life medical expenses can be really appealing. And that's just having a will that's well thought out that leaves your spouse a trust. It's, you know, that's all it takes. And then beyond that, even for adult kids, same concept, right? Your kids are grown now, and you love them, you want to take care of them, and maybe you've got a couple $1 million between your home equity and your retirement accounts and your life insurance. Consider leaving them the same kind of a trust that you'd leave your spouse, right? I'm going to leave my kids each a trust. They're their own trustees because they're in their 30s now, maybe. They can have broad access to the money. Or maybe you got the kid who can never be their own trustee. Maybe someone else has to be the trustee. But let's say, no, they're doing well. They can have access, control, but their trust is protected if they ever get divorced. And their trust is protected if they're ever involved in a lawsuit or if they end up in a nursing home. Because let's face it, you know, these days people live longer, kids inherit in their 60s. They don't really need to spend their inheritance. It'll be a nice boost for their retirement. And then whatever they don't spend, if you use a trust, when the kids die, it goes tax-free and free of probate on down to the next generation. So people who have grandkids love that estate plan. That's just a very common plan these days for people who think it through. It doesn't take that long to figure it out. You know, you need to pick your trustees. You need to understand kind of who your beneficiaries are, and you can work through it. But you know, that's a lot of the work we do these days. The healthcare directive is pretty automatic. The powers of attorney, you pick the people you trust. You know, the real thought for estate planning goes into, okay, do we need wills? Probably. Just wills. Do we need a living trust? Maybe. And then, but what kind of trusts are we going to leave to our spouses, partners, sister and her kids, parents, children? Thinking through the way that you can use a trust when you die to just provide some asset protection and provide for the right people is where we put the effort in. And it's, you know, it's really powerful stuff with what people have accumulated these days between home equity and retirement accounts. You want to be thoughtful about it. You don't have to spend 12 hours on it, but spend an hour or 2 on it and you can have a good plan set up.
You know, one of the things that you said to me when I came out and we sat down was that once you get this thing set up, you're kind of set. It's in place. You can put it in a drawer. Your attorney has it. Like someone can find it in that event. When I walked into that meeting, I thought that like we were going to sit down every year and go over this, that, and the other. But I mean, from an ongoing maintenance standpoint, assuming you're not Warren Buffett, right? What does kind of that whole process look like from the time someone would sit down with you to what kind of information do they have to gather and give to you? And then what does that next 10, 15, or 20 years look like with those documents?
Yeah, good question. So we typically hear from our clients like maybe every 10 years or so. We recommend that they reach out if there's a major life change, or every 5 years, so we can just touch base and check in and see if we need to change a backup here or there. But we draft the documents to be long lasting. It's not hard to think 2 contingencies deep on things happening and having a couple of backups so the documents are durable. You should only have to do this once and then do maintenance every 5 to 10, 15 years. But even then tends to be a pretty small project. It's not great for our business model, to be honest. I wish I could be doing new wills for people, every year. It'd be better for us to be like a CPA and do their taxes every year. But no, you really just kind of have to do it well once and then kind of maintain. Most people after that, once you get it set, you're kind of on autopilot for a while.
Yeah, that's great. And that was one of the reasons for everybody who's watching why I was comfortable, bringing Kanoa and talking to my clients about him. Because I think I had the same thought about him as a lot of my clients. One of the things they ask me is like, how do you make money? You're not like selling me anything. You're just like, you're just like helping. And so when we sat down and you kind of told me that was the life cycle of this, I went, oh, cool, somebody I can trust, right? And I think that's what people deserve, and I think that's what they're looking for. So I run across every now and then doing a financial plan, and I'll come across somebody very hardworking, somebody who's built some retirement stuff, but they're not, again, Warren Buffett. They're comfortable. Is there like a bright line rule where we have to start getting into esoteric, like charitable unit remainder trusts and all these kind of stuff? Like, is there a certain threshold of net worth or wealth that someone might need some more advanced planning with? Or should everyone just kind of have that basic suite of like, would that suffice for 95% of the people?
Yeah, good question. So really 95% of the people are covered by a very simple estate plan, which is if you're married or partners, you leave your partner a trust. When you're both gone, the remainder beneficiaries get what's left. By having that structure in place, you can protect $4.4 million from Washington estate tax, and you can protect $26 million from federal tax. So very few people have to worry about federal tax these days, but the Washington tax is a real thing. And having just a basic trust structure between a married couple or partners protects 4.4 very easily. And most people don't need to do more than that. If you're single, you're limited to 2.2 million. So, you may have to work a little bit harder if you're over 2.2 million, but the loophole, if you're single and over 2.2 million, or if you're married and over 4.4 million, you just need to make gifts late in life before you die, because Washington does not keep track of your lifetime gifts. You can make a deathbed gift of $13 million and that's tax-free. Washington only cares what you have after that. They only care what you have at the time of your death. So even if you give it away at the very end, that's completely tax-free. So people just need to know the rules. If you're over 4.4 million and you're in a couple, or over 2.2 million and single, you just need to know the rules that, hey, I need to make some gifts late in life. I may not see it coming, so there's some risk there, but I know that my option is to make gifts before I die. And then that's really all the tax planning I need. I don't need to do a charitable remainder trust. I don't really need to, move things overseas or do anything illegal, right? You don't have to do anything illegal. The estate tax is optional as long as you know the rules and you're prepared to act, and you've got people that you can trust to be your power of attorney. If you become incapacitated and you can delegate that gifting to somebody else, that's another way that we can get around the estate tax. So just kind of understanding those rules. For most people, it's pretty simple to eliminate estate taxes. If you're over 10 million, then you think about some additional techniques to build on to the basic plan to minimize tax with charitable bequests or just more aggressive gifting. But even then, it's really not that complicated these days. The laws are really generous.
Yeah, and I know that I use like irrevocable life insurance trusts and things like that to pass things, to, especially I've found with small business owners, people with illiquid assets. Like I'm looking on our list here, and I know that we have a restaurant owner on here with us. I have a farmer over in Colfax who has a substantial estate. So when the government comes and wants to extract cash out of those illiquid assets too, a lot of times we have to plan for that. So yeah, no, all good stuff. Anything else? Any other high level kind of issues or topics?
No, that's a good point. If you're illiquid, like if you have a farm or a business and it's valuable and you probably don't feel wealthy, right? When all your wealth is tied up in an asset and it's not all just cash. But the IRS wants its part if you value it, and that's going to be triggering tax at the federal level, which now we're talking about a 50% tax. Then that's where life insurance really matters. And if you're going to buy a life insurance policy to deal with estate taxes, that means it's probably a pretty big policy. And so there's such an easy way to avoid that policy being subject to estate tax. You don't want to just buy a $5 million life insurance policy and own it, because that's going to get a 50% haircut. So instead, you set up a trust, have the trust buy the life insurance, gift the premiums to the trust each year, perfectly legal, not sketchy. That trust is protected from estate taxes. That $5 million when you pass away, tax-free to your heirs to pay the estate tax. You don't have to sell the farm. So good. I'm glad you brought up life insurance trust, because those are things that people don't necessarily know about or miss. And sometimes the person selling the policy doesn't want to slow down the process, so they don't necessarily talk to your other advisors about, hey, you're buying a $5 million policy. Like, how do we want to take ownership? You and I, Chris, would know, hey, that should be in a trust.
Right.
Whereas, the client might not know that.
Yeah. And I think all that fits really well. I do, especially the federal estate tax now, but a lot of the planning I do centers around governmental uncertainty and like where things would go in the future. So for everybody listening, man, don't we all wish we had to go to Kanoa and set up to protect that last 20 millions of our net worth? But Congress tomorrow could get together and reduce or eliminate, the federal tax exclusion and bring all those numbers down. State of Washington could do the same thing. And I think that's really where the value of having like someone trusted, an advisor like Kanoa, like Megan, where you can come and say, oh man, I saw on CNN this estate tax thing is happening, or the state of Washington is this, or whatever. And I know, just having that outlet for someone to call and talk to is super important. And everybody needs one. I'm a financial advisor. I need one. So I think I have asked all my questions. If you're attending right now and you want to raise your hand, there should be a button down at the bottom of your, if you have any questions that you'd like to answer, you can type them in or I'll let you on. Or if we have no other questions, and Megan and Kanoa, if you guys want to wrap up with anything, I kind of think about 30 minutes and people are getting hungry. So yeah, it doesn't look like any questions. So do you guys have anything else, anything for the parting shots?
Megan, you have anything?
I was just going to mention that whether you're very wealthy or you're not very wealthy, it's still important to do estate planning, no matter your net worth. Just so you can make sure that you're taken care of and your family is taken care of and your farms and your businesses are well taken care of when you pass away, or even if you just become incapacitated. So we're happy to help anyone of any net worth.
Okay, and actually, so I do have Janelle. We're going to allow Janelle here real quick to ask a question. Go ahead, Janelle, you're going to want to unmute. Yep, there you go.
I just wanted to know how to get a hold of you, to call you to make an appointment.
You can call Chris, or
Oh.
you can Google Ostrom Law.
I've got all his contact information.
Pretty quick.
Oh, okay, good.
Yeah,
And
perfect.
that segues into what I wanted to say. My takeaway point was the value of having your wealth advisor and your attorney work as a team is we do all this great planning. We get people to sign their wills and everything. And then they have $1 million IRA and they don't update the beneficiary. Right? The beneficiary still names the ex-wife or names their estate as beneficiary, which triggers income tax. So point is, reach out to a live person, a wealth advisor like Chris, to us. The things we can do is so easy for us. If you ask a good question like you just asked, how to reach us. But if you ask a question, we can get rid of all the noise, and we don't mind answering questions. We want people to ask questions. We don't send bills for that. But getting your beneficiary designations updated is huge.
Huge. Yeah, for
The
sure.
laws around that are so complicated and archaic. If you do it wrong, it's a disaster. And making sure that you have your retirement accounts and your life insurance beneficiaries updated. That's the takeaway. All of you who have good wills, double check that. If you don't have a will yet, know that's going to be part of the process.
Yeah, and the worst part, anytime I've gone through that with the client, is not the money's one thing. Nobody likes writing a check to the IRS, but at the moment you're dealing with the loss of someone, just the last thing on earth you want is to be on the phone with a custodian arguing over this tax withholding or something like that. So yeah, that's a huge point, is that type of thing does actually require like annual reviews, maintenance, and that kind of thing. So that looks like about it. Appreciate you guys coming out, staying up and helping my clients out. Really, really appreciate you.
Our pleasure. We look forward to continuing the partnership, Chris. We like working with you and your clients. And we're happy to be here. Thanks again.
Awesome. Cool, guys. Well, anybody who needs anything, absolutely feel free to reach out to me. You can reach directly out to Kanoa if there are any issues that we need to take care of in your financial plan that got brought up here. That's easy enough done. And yeah, everyone have a great evening. All right. Bye,
Thanks,
guys.
Chris.
Bye, Ron.